Case 1. Father Neil Doherty, Archdiocese of Miami. A forensic investigation into the personnel records of the Archdiocese of Miami would later reveal something that investigators described as one of the most extensive patterns of clergy misconduct ever documented in the United States. The subject was a Catholic priest who had served the same archdiocese for more than 3 decades. His name was Father Neil Doherty, and by the time law enforcement brought formal charges against him, more than 4 decades had passed since his ordination. What prosecutors presented in a Broward County courtroom in January of 2013 was not a sudden discovery. It was the end of a paper trail that the church itself had been quietly compiling and quietly suppressing since at least 1972. Neil Doherty was ordained in 1969 and was assigned to parishes across the Archdiocese of Miami over the next 33 years. His assignments included St. Vincent's Catholic Church in Margate, St. Anthony in Fort Lauderdale, and St. Philip in Northwest Miami-Dade. Within those parishes, he was assigned to youth ministry and pastoral counseling, roles that provided structured, unsupervised access to young people. Attorneys who later reviewed the full scope of his conduct across those decades described the documented pattern as among the most extensive ever recorded in a single priest case in the United States. Investigators used the word prolific in their legal filings. He was never prosecuted during any of those active ministry years. The internal church record tells a different story from the public one. Documentation obtained through civil litigation and investigative reporting reveals that a fellow priest flagged concerns in 1972, noting that Doherty had adopted a young boy who was sleeping in his bedroom. That report went nowhere institutionally. In 1983, a psychologist who evaluated Doherty flagged concerns about his conduct with minors. No formal action was taken. In 1987, a church secretary reported what she described as direct knowledge of misconduct. According to civil complaint filings, she was terminated from her position shortly thereafter. A formal psychological evaluation conducted in 1992 concluded with a recommendation that Doherty be removed from active ministry. That recommendation was not acted upon. He remained in his pastoral role for 10 more years. The formal unraveling of Doherty's ministry began in April of 2002, when Archbishop John Favalora undertook a comprehensive review of approximately 400 priest personnel files in the Archdiocese of Miami. That review was conducted in the broader context of the national clergy abuse crisis that had emerged publicly that same year. Doherty was permanently removed from active ministry that month. A Broward County State Attorney investigation followed, lasting 17 months. During the course of that investigation, named victims came forward and provided sworn accounts of their experiences. The investigation centered on conduct that had allegedly occurred decades earlier, which created significant legal challenges under Florida statutes of limitation. Prosecutors ultimately proceeded on charges tied to specific named complainants. On January 14, 2013, Neil Doherty appeared in Broward County Circuit Court and entered a plea of no contest to 6 counts of lewd and lascivious acts upon a child. The plea agreement was accepted. 2 weeks later, on January 28, 2013, he was sentenced by a Broward County judge to 15 years in state prison, the maximum sentence available under the terms of the plea. Doherty was 69 years old at sentencing. 2 named victims, Dennis Montero and Jorge Soler, addressed the court during the sentencing hearing. Montero gave a victim impact statement in which he described what had been documented in the legal record. He stated that he had been given a drink that had been altered and that he awoke without clothing. His account was consistent with the investigative findings that prosecutors had built the case around. Soler also addressed the court. The prosecution's case described a method that investigators characterized as systematic. According to the charging documents and testimony, Doherty used drinks given to minors that contained substances not disclosed to them. He also used sessions framed as counseling or hypnosis during which he had unsupervised physical access to minors. These methods appeared repeatedly in the accounts of multiple named complainants across different years and different parish assignments. Forensic review of the conduct was complicated by the passage of time, but the number of individuals who came forward with consistent accounts formed the evidentiary basis for the charges that ultimately resulted in conviction. The civil litigation that ran parallel to the criminal case resulted in the Archdiocese of Miami settling 6 civil suits in 2006 for a combined $750,000. 7 additional named plaintiffs, identified as John Doe complainants, filed separate suits, most of which were resolved for undisclosed settlement amounts. In June of 2025, more than 20 years after Doherty's removal from ministry, an 8th John Doe civil lawsuit was filed in Miami-Dade Circuit Court, indicating that the legal consequences of his conduct in ministry continued to extend decades into the future. Doherty served approximately 10 years of his 15-year sentence before being released. Under the terms of his release, he is required to register as a sex offender under Florida law. The Archdiocese of Miami issued a formal public statement following his removal that described him as permanently removed from active ministry within both the Archdiocese and the Universal Catholic Church. Civil filings in related lawsuits named Archbishop Edward McCarthy, who served the Archdiocese during portions of the period when complaints were documented, and alleged institutional knowledge without institutional action. The Archdiocese disputed the characterization in those filings. The Florida Attorney General's investigation, released in November of 2020, included the Archdiocese of Miami within its statewide review. That report identified the Archdiocese as having the highest number of credibly accused priests of any Florida diocese, 43 individuals total. It also documented that the Archdiocese had paid a combined $26,100,000 in settlement, legal, and counseling costs since 1966. The Doherty case was among the most extensively documented in that statewide review, and it illustrated the central finding of the report, that internal church personnel records contained warning documentation years, and in some cases decades before any civil or criminal authority was formally contacted. For investigators and legal analysts reviewing the Florida AG report, the Doherty case served as a reference point for understanding how institutional personnel practices could allow an individual to remain in a position of trust over a period measured not in months or years, but in decades. The case was not unique in its structure. The report identified similar patterns in other Florida dioceses, but the volume of documented internal warnings and the length of the documented ministry period made it one of the most extensively reviewed cases in the entire statewide investigation. The Broward County prosecution was the only criminal proceeding to result from his conduct. He entered no contest to 6 counts. He received 15 years. He served approximately 10. He is now on the sex offender registry. The names of more than a dozen individuals who came forward as complainants remain in the civil court record of the Archdiocese of Miami. Case 2. Father Jean-Claude Jean-Philippe, Homestead, Miami-Dade. The complaint that led to the arrest of Father Jean-Claude Jean-Philippe was not filed by a stranger, not by an anonymous tip, and not by an investigative journalist. It was filed by a woman who had known the priest for years. He had officiated her wedding. He was the godfather of her children. Her family had vacationed with him. She considered him a trusted member of her household. That relationship, and the platform it created, was precisely what the subsequent criminal investigation and trial addressed. The case raised formal questions in a Miami-Dade courtroom about how position and personal trust can be used in ways that result in criminal harm to someone who had every reason to believe they were safe. Jean-Philippe was 64 years old at the time of his arrest. He was a member of the Congregation of Priests of the Mission, known as the Vincentians, and was assigned to Sacred Heart Catholic Church in Homestead, a parish in Miami-Dade County. His role there was that of a parish priest with pastoral responsibilities, and his relationship with the named complainant had developed over the course of years of regular pastoral contact. The incident that triggered the investigation occurred in October of 2018. Jean-Philippe invited the woman to his residence, which was located on the grounds of Sacred Heart Church. She accepted the invitation because of the long-standing relationship and had no reason to believe the visit posed any concern. According to her sworn account and the police report filed afterward, she was offered an iced tea by Jean-Philippe during the visit. After drinking it, she lost consciousness. She awoke approximately 2 hours later in his bedroom without her clothing. Jean-Philippe was present. She contacted law enforcement after confiding in another priest associated with the parish, Reverend Silverio Rueda. The Archdiocese of Miami received her formal complaint on March 4, 2019, and directed her to contact law enforcement. Jean-Philippe was arrested on March 15, 2019, and charged with sexual battery on a physically incapacitated victim, a first-degree felony in Florida. During the initial police questioning that followed his arrest, Jean-Philippe made statements to investigators in which he acknowledged that he had removed the woman's clothing, administered oil to her body, and made physical contact with her without her consent. He later recanted those statements, telling the court that his initial account to police was inaccurate and had been given under pressure. His recantation became a central issue during the trial. Prosecutors argued that the original statement was consistent with the physical evidence and the complainant's account. Defense attorneys argued that the statement was unreliable and had been improperly obtained. The trial proceeded in October of 2021. The jury was all female. Over approximately 1 week of testimony, the jury heard from the complainant, from investigators who had processed the scene and conducted the arrest, and from witnesses with knowledge of the relationship between Jean-Philippe and the victim's family. After approximately 2 hours of deliberation, the jury returned a verdict of guilty on the charge of sexual battery on a physically incapacitated victim. Sentencing took place on February 17, 2022, before Miami-Dade Circuit Judge Carmen Cabarga. Prosecutors argued for a sentence of 15 years, consistent with the charge classification. The defense argued for a lesser sentence, citing Jean-Philippe's age, his decades of pastoral service, and the absence of prior criminal convictions. Judge Cabarga sentenced Jean-Philippe to 94.5 months in state prison, approximately 7 years and 11 months. The sentence fell below the 15 years the prosecution had requested, but represented a formal judicial determination that the conduct met the statutory threshold for a substantial prison term. The Archdiocese of Miami's response to the complaint began on the same day it received the formal report, March 4, 2019. Archbishop Thomas Wladyslaw issued a directive that Jean-Philippe be immediately removed from Sacred Heart Parish and placed on administrative leave pending the outcome of the investigation. That directive was carried out the same day. The Archdiocese later issued a public statement acknowledging the harm caused by the conduct and expressing direct acknowledgement of the impact on the named victim, her family, and the broader parish community. The Vincentian Order, as Jean-Philippe's religious community, was also notified. The Homestead case represented a category of clergy misconduct that received less national attention than cases involving minor victims, but raised equally serious questions about position of trust, access, and institutional accountability. Florida law treats sexual battery on a physically incapacitated victim as a serious first-degree felony precisely because of the vulnerability created by incapacitation. The legal question is not just the conduct itself, but the deliberate exploitation of a condition in which the victim cannot consent or resist. The charge and subsequent conviction address those elements directly. In broader terms, the case raised questions that investigators, victim advocates, and church accountability organizations highlighted in their reviews of the verdict. How often pastoral relationships involving sustained personal trust create conditions that are difficult for potential victims to identify or report, and how institutional response protocols function or fail to function. In cases where the complaint involves an individual embedded in a trusted community context, the Archdiocese's same-day response upon receiving the formal complaint stood in notable contrast to the documented patterns in cases like Doherty's, where internal records showed complaints going unaddressed for years. Whether that contrast represents institutional change or individual circumstance was a question civil litigators and church accountability organizations continued to examine in the years following the verdict. Jean-Philippe's conviction stands in the Miami-Dade Circuit Court record. He was 68 years old when sentenced. He had entered active ministry in the Vincentian Order decades earlier. His assignment to Sacred Heart in Homestead was the assignment from which he was removed on the day the Archdiocese received the complainant's report. The jury deliberated for 2 hours and returned a unanimous guilty verdict. The judge imposed 94.5 months. He was removed from Sacred Heart in March of 2019. His trial concluded in October of 2021. His sentence was handed down in February of 2022. Case 3. Monsignor John Skehan and Father Francis Guinan, Delray Beach. An anonymous letter arrived at the Palm Beach County State Attorney's Office in April of 2005. It described financial misconduct at a Catholic parish in Delray Beach. The letter did not come with a name attached, only a description of a system that the writer claimed had been operating for years inside St. Vincent Ferrer Catholic Church. What followed was a forensic accounting investigation that would ultimately document one of the largest financial crimes ever recorded in the history of the American Catholic Church. The figure at the center of the criminal proceedings was not one priest. It was two successive pastors of the same parish, operating under the same scheme, across a combined period that spanned approximately 4 decades. Monsignor John Skehan served as pastor of St. Vincent Ferrer in Delray Beach for 40 years, from 1963 until his retirement in 2003. During that time, the parish grew substantially in both membership and financial contributions. The congregation included many affluent donors, and the weekly offertory collections were substantial. When Skehan retired in 2003, Father Francis Guinan was named his successor. By the time investigators closed the investigation, the forensic accounting firm Michelson and Company of West Palm Beach had calculated total misappropriated funds at approximately $8.6 million, attributed across both pastoral tenures. The mechanism of the scheme was straightforward in structure, if difficult to detect over time. Skehan had established bank accounts that were not disclosed to the Diocese of Palm Beach. One of those accounts was labeled with a name that resembled a legitimate parish ministry designation. Investigators and press accounts referred to it as the Holy Name account. Cash from the weekly offertory collections was diverted into these off-the-books accounts rather than deposited into the parish's official diocesan accounts. Financial documents that would have revealed the discrepancy were shredded when auditors began their review. Parish bookkeepers assisted in maintaining the concealment over a period of years. Investigative records documented how Skehan used the misappropriated funds. Investigators identified real estate purchases in Palm Beach County and in County Kilkenny in Ireland. A condominium on Singer Island valued at $455,000 was traced to the hidden accounts, as was a purchase in the 400,000s of a rare gold coin collection. Expenditures included airline tickets for personal travel, payments related to multiple trips to casino and gambling venues in Las Vegas and the Bahamas, and the purchase of a pub in Ireland. Skehan had no disclosed secondary income source that would account for these assets on a pastor's salary. Guinan, who became pastor in 2003 following Skehan's retirement, continued the diversion of funds. Financial records linked his use of the off-the-books accounts to personal travel, gambling activity, and payments to a bookkeeper at another church with whom investigators documented a personal relationship. During the course of the investigation, when the Diocese of Palm Beach launched an independent audit alongside the criminal inquiry, Guinan wrote a letter to church officials. In that letter, investigators noted, he urged the diocese to cease the audit process, describing it in terms that prosecutors later cited as consciousness of guilt. The letter became a key piece of documentary evidence. Both Skehan and Guinan were arrested in September of 2006. Skehan was apprehended at Palm Beach International Airport by law enforcement as he was attempting to board a flight to Ireland. The timing of the arrest, as he was at the departure gate, was noted in press accounts as an indication that investigators had been monitoring his travel. Both men were charged with grand theft. Jury selection in Skehan's case was scheduled to begin in January of 2009. On the morning of January 21, 2009, the day jury selection was to commence, Skehan entered a guilty plea to the charge of grand theft over $100,000. Skehan appeared before Judge Jeffrey Colbath for sentencing on March 24, 2009. He was 81 years old. Dozens of letters from parishioners and community members had been submitted to the court requesting leniency, citing his decades of pastoral service and community contributions. Judge Colbath acknowledged those letters, but noted that the conduct they were seeking to mitigate was, as he stated from the bench, a matter of sustained financial exploitation of a community that had trusted him. Colbath sentenced Skehan to 14 months in state prison, followed by 7 years of probation and required restitution. By the time of sentencing, Skehan had already repaid approximately $787,000 toward the total stolen amount. Guinan's case proceeded to trial. A 6-member jury convicted him of second-degree grand theft. He appeared before Judge Krista Marks for sentencing on March 25, 2009. one day after Skehan's sentencing. Judge Marks sentenced Guinan to 4 years in state prison, plus restitution, and ordered that he be permanently banned from any presence on the grounds of St. Vincent Ferrer Catholic Church. The Diocese of Palm Beach had already stripped both men of their priestly faculties, the canonical authority to perform priestly functions, during the proceedings. The broader institutional context of the Skehan and Guinan case was examined in the aftermath of the convictions. The Diocese of Palm Beach had no independent financial oversight structure that had detected the diversion of funds during the 40 years of Skehan's tenure. The offertory cash system, in which collections were counted by parish volunteers or bookkeepers without external audit, created conditions in which systematic diversion could remain undetected for extended periods. Following the convictions, the Diocese of Palm Beach and other Florida dioceses reviewed their internal financial controls. The anonymous letter that initiated the criminal investigation arrived after Skehan had already retired. Had the scheme continued undetected until Guinan's eventual retirement, investigators noted, the total amount would have continued to grow. The Skehan and Guinan prosecutions were not classified as misconduct cases involving personal harm to parishioners of the type documented in other clergy cases. They were financial crimes. But the parish and diocesan community response documented in contemporaneous press coverage reflected a form of institutional harm. The removal of funds that parishioners had donated in good faith for ministry, outreach, and community service. The forensic accounting investigation, the criminal prosecution, and the trial record that resulted are among the most extensively documented clergy financial crime cases in Florida court history. Case 4. Father Robert Schaeufele, Diocese of St. Petersburg. The criminal case against Father Robert Schaeufele did not begin with a single complaint. It began with a pattern. By the time Pinellas County prosecutors filed formal charges in 2002, the Diocese of St. Petersburg possessed a personnel file on Schaeufele that documented concerns dating back to within the first years of his ordination in 1975. The criminal proceedings that followed centered on 3 former parishioners at Sacred Heart Church in Pinellas Park, all of whom had been between the ages of 9 and 11 during the period covered by the charges, roughly 1983 to 1985. The ultimate sentence was 30 years in state prison. The early release that followed became the subject of its own legal and public controversy. Schaeufele was ordained into the Diocese of St. Petersburg in 1975. According to documents later obtained through civil litigation and investigative reporting, complaints about his conduct with minors reached diocesan officials as early as that same year. Rather than pursuing formal investigation or reporting the complaints to law enforcement, the Diocese of St. Petersburg transferred him repeatedly across parishes over the following 2 decades. His assignments included Sacred Heart Church in Pinellas Park, Epiphany Cathedral in Venice, Cathedral of St. Jude in St. Petersburg, St. Rita in Dade City, and St. Michael the Archangel in Pasco County. Each transfer placed him in a new community with a new group of parishioners who had no knowledge of the complaints in the previous assignments file. The criminal charges that brought the case to a Pinellas County courtroom in 2002 were based on specific conduct documented by 3 named complainants. All 3 had been minors during the period in question at Sacred Heart Church. One named victim, Jeff Rosanowski, provided extensive testimony about what had occurred. Court filings describe conduct that spanned a period in which Schaeufele had established an ongoing relationship with Rosanowski's family. The charges against Schaeufele were classified as capital sexual battery, the most serious classification in Florida law for this type of offense, carrying a potential life sentence. A formal complaint from a specific victim in April of 2002 prompted the diocese to act. Bishop Robert N. Lynch removed Schaeufele from active ministry upon receiving the complaint. Additional named complainants came forward publicly in the weeks that followed. By the time the investigation concluded, at least 22 men had come forward with accounts of conduct during Schaeufele's various parish assignments over the prior decades. The criminal charges, however, proceeded on the specific Pinellas County counts, with an additional count filed in Pasco County. Rather than proceed to trial, Schaeufele entered a guilty plea to amended charges of attempted capital sexual battery on multiple counts, 2 in Pinellas County and 1 in Pasco County. The distinction between capital sexual battery and attempted capital sexual battery affected the sentencing calculation but was part of the negotiated resolution of the case. Skehan appeared before Circuit Judge Wayne Cobb in Pasco County and before the Pinellas County Court for sentencing proceedings in June of 2003. The court sentenced him to 30 years in state prison, with sentences in the two jurisdictions running concurrently. Prosecutor Tim Hessinger represented the state. The 30-year sentence was widely understood in the context of Florida's sentencing law in 2003 as a substantial prison term that would keep Skehan incarcerated well into old age. What neither the prosecution, the victims, nor most observers anticipated at the time of sentencing was the consequence of a provision in Florida law relating to crimes committed before 1998. Under Florida's pre-1998 sentencing structure, inmates could earn substantial gain time reductions in their sentences for compliance with institutional rules and participation in programs. The Florida legislature changed this system in 1998 to require that inmates serve at least 85% of their sentence. That change, however, could not be applied retroactively to crimes committed before the law took effect. Because the conduct underlying Skehan's charges had occurred in the period from 1983 to 1985, more than a decade before the 1998 reform, he was eligible to earn gain time under the older, more generous framework. As a result of that accumulated gain time, the Florida Department of Corrections released him in February of 2015, after he had served approximately 12 years of his 30-year sentence. The Tampa Bay Times reported extensively on the release. Victims who had testified, waded through the legal proceedings, and believed the 30-year sentence represented a meaningful resolution expressed direct and documented opposition to the early release. Their response was part of a broader debate in Florida about the retroactive sentencing provision and its application in cases involving crimes against children. The civil litigation that accompanied the criminal case resulted in the Diocese of St. Petersburg paying more than $1 million to settle claims from 12 named plaintiffs in 2004. At least 6 additional civil lawsuits were filed in subsequent years. The diocese placed Skehan on its official list of credibly accused priests, which was published as part of its compliance with the standards adopted by the United States Conference of Catholic Bishops following the 2002 national crisis. The diocese's public statement regarding Skehan's personnel file included a claim that no formal allegations of misconduct appeared in the file prior to the April 2002 complaint, a statement directly contradicted by civil discovery documents obtained in subsequent litigation. The Skehan case occupies a significant place in the Florida clergy accountability record not only because of the number of named complainants, at least 22, or the severity of the charges, but because of what it demonstrated about the interaction between institutional transfer practices, statute of limitations barriers, and retroactive sentencing provisions. Each of these 3 factors, independently, created limitations on what the legal system could achieve. Together, they resulted in a case in which documented complaints from 1975 resulted in a 30-year sentence not handed down until 2003, and in which the individual who received that sentence was released after serving approximately 12 years. Case 5. Father Thomas Anthony Crandall, Diocese of Pensacola-Tallahassee. The traffic stop that ended Father Thomas Anthony Crandall's ministry and began his criminal record took place on a Saturday night in January of 2002 on a highway between New Orleans, Louisiana, and the Florida Panhandle. DEA agents and deputies from Santa Rosa and Escambia counties had been building a case based on information from a confidential informant. An individual arrested the previous month in possession of 42 ecstasy tablets who had provided information about the source. When law enforcement pulled Crandall's vehicle over that night, what they found in the car and subsequently in his rectory at St. Rose of Lima Church in Milton, Florida, represented one of the most documented cases of drug trafficking directly tied to a Catholic clergy member in Florida history. It was not, as subsequent events would reveal, the only criminal matter Crandall would face. Within a few years of his federal drug conviction, he faced a second, separate criminal prosecution, this time on state charges related to child exploitation material. He was convicted in both cases. Crandall had been ordained into the Diocese of Pensacola-Tallahassee and was assigned to St. Rose of Lima Church in Milton, in the Florida Panhandle, at the time of his arrest. He had previously been assigned to St. Joseph's Church in Port St. Joe. During the search of his vehicle following the traffic stop on January 12, 2002, agents recovered 900 ecstasy tablets and approximately 10 grams of methamphetamine. A subsequent search of his rectory at the church grounds recovered an additional 15 grams of methamphetamine and 4 additional ecstasy tablets. The investigation that followed examined both the source of the substances and the financial system that had funded the lifestyle documented in the case record. The financial dimension of the case was notable. Crandall's official annual salary as a diocesan priest was $17,175 per year. The investigation documented that he owned a condominium on Bourbon Street in the French Quarter of New Orleans. His documented expenditures included European travel, attendance at University of Notre Dame football games, and personal travel that his salary would not have supported. A review of financial records at St. Joseph's Church in Port St. Joe, his prior assignment, revealed that thousands of dollars were unaccounted for and that the parish had accumulated $77,000 in unpaid assessments owed to the diocese. These financial discrepancies formed part of the broader criminal picture and were included in the restitution calculation ordered by the federal court. Crandall entered a guilty plea in federal court to the charge of conspiracy to possess methamphetamine with intent to distribute. The sentencing was handled by United States District Judge Roger Vinson in the Northern District of Florida. Judge Vinson sentenced Crandall to 51 months in federal prison and ordered restitution in the amount of $83,225, representing funds that investigators had determined were misappropriated from St. Rose of Lima during his tenure. Bishop John Rickard of the Diocese of Pensacola-Tallahassee addressed the parishioners of St. Rose of Lima directly in the days following the arrest. Crandall was permanently removed from ministry in 2002. He was subsequently included on the diocese's credibly accused priests list published in 2020 as part of the diocesan compliance review ordered by the Florida Attorney General's investigation. The second criminal case against Crandall arose while he was on federal supervised release following his federal prison term. In 2005, he was identified through an undercover law enforcement operation in Mobile, Alabama. Gulf County Sheriff's investigator Chris Buchanan had been working an undercover operation in an online chat room environment and made contact with Crandall. FBI agents executed a search of Crandall's apartment and recovered materials classified as child pornography under federal and Florida law. He was charged in Florida State Court with 2 counts of transmission of child pornography over the Internet. The state case proceeded to a jury trial, which concluded in June of 2006. The jury returned a guilty verdict on both counts. The maximum sentence for each count of transmission of child pornography under applicable Florida law at the time was 5 years in state prison. The sentencing court imposed the maximum on both counts, running them consecutively, a combined sentence of 10 years in state prison. Upon release from Florida State Prison, Crandall faced additional federal consequences for violations of his federal supervised release conditions that arose from the new criminal conviction. His name appears on the Florida Sex Offender Registry. The Crandall case was unusual within the broader Florida clergy crime record in that it involved 2 entirely separate categories of felony conviction: federal drug trafficking and state child exploitation offenses, arising from 2 separate investigations conducted several years apart. The federal case, resolved in 2002, established his initial conviction record and removed him from ministry. The state case, which arose in 2005 while he was still under federal supervision, resulted in his second criminal conviction and his second prison sentence. The sequence demonstrated that the removal from ministry in 2002 had not ended the underlying conduct patterns that law enforcement subsequently identified. From an investigative standpoint, the 2 cases involved different law enforcement agencies, different jurisdictions, and different investigative methods. The federal drug case originated from a confidential informant arrest and a highway traffic stop. The state child exploitation case originated from an online undercover operation. Neither investigation was initiated by the diocese. Neither was the result of an internal church review or personnel file flag. Both were the result of independent law enforcement operations that intersected with Crandall's conduct at points that had no direct connection to his prior assignment or removal from ministry. For the Diocese of Pensacola-Tallahassee, The Crandall case was among the most extensively documented in the 2020 credibly accused priests list that the diocese published under the Attorney General's review. The diocese had 10 named diocesan priests on that list, plus 9 additional non-diocesan clergy with connections to parishes within the diocese's territory. Case 6. Father Wladyslaw Gorak, Diocese of Orlando. In December of 2004, the Diocese of Orlando received a new priest on assignment. Father Wladyslaw Gorak, ordained originally in Poland and most recently associated with the Archdiocese of Newark in New Jersey. He was assigned to the Church of the Resurrection in South Lakeland, in Polk County, Florida. He had been given a letter of recommendation. Within weeks of his arrival, a woman in the Lakeland parish recognized him. She had known him in New Jersey. He had been following her for months while she was living there, showing up at shopping centers and malls she frequented. When she moved to Florida, the contact had stopped until the day she saw him assigned to her parish. The documented events that followed over the next several months resulted in Gorak's arrest in May of 2005, a guilty plea to multiple felony counts, and a civil settlement paid by 2 dioceses. The case also produced a formal legal record of what investigators and civil attorneys described as institutional negligence in the handling of a documented risk. The foundational document in the Gorak case is a confidential memorandum from 1998, written by a supervisor in the Archdiocese of Newark. That memo documented complaints from female parishioners about Gorak's behavior, which was characterized as sexually aggressive. The memo was placed in his personnel file and was known to Newark Archdiocesan officials. It was not provided to the Diocese of Orlando when Gorak sought a transfer assignment in 2004. Instead, Auxiliary Bishop Arthur Saratelli of the Archdiocese of Newark provided a sworn affidavit characterizing Gorak as suitable for ministry and as a person of good moral character. That affidavit formed the basis of the Diocese of Orlando's decision to accept him into a parish assignment. According to court filings and law enforcement records, conditions were placed on Gorak's assignment at the Church of the Resurrection that specifically prohibited him from having unsupervised contact with minors. The existence of those conditions indicated that the Diocese of Orlando had received at minimum some information suggesting the need for restrictions, though the full extent of what Newark had disclosed remained disputed in subsequent civil litigation. The named complainant, a woman from the New Jersey parish where Gorak had previously served, was not informed of his assignment in Lakeland. She informed the senior pastor, Reverend Matthew Mello, that she recognized Gorak and described the history of unwanted contact in New Jersey. Mello told her he would address the situation. The contacts continued. The incident that resulted in the criminal charges occurred in October of 2004. According to the criminal complaint and related civil filings, Gorak entered the woman's home and, during the encounter, engaged in conduct that resulted in charges of burglary with assault, false imprisonment, aggravated stalking, and battery. Law enforcement documents note that the woman was able to leave the residence and sought help. She was not wearing her full clothing when she fled. Gorak remained in his parish assignment at the Church of the Resurrection through December of 2004, when the Diocese of Orlando terminated his ministry assignment. After that termination, the Archdiocese of Newark sent letters of recommendation on his behalf to 6 other Florida dioceses, doing so within 8 days of the Orlando termination. Gorak was arrested by Lakeland police on May 17, 2005, on the charges arising from the October 2004 incident. Reverend Matthew Mello, the senior pastor who had received the complainant's earlier reports, himself sought a formal restraining order against Gorak in April of 2005, telling authorities that he felt personally unsafe in Gorak's presence. That request for a restraining order from the priest's own pastoral superior was a documented element of the record that civil attorneys for the victim later cited in their claims against both dioceses. The criminal case was resolved in 2007 when Gorak entered a guilty plea to the charges. The court sentenced him to 4 years of probation, with mandatory treatment and counseling requirements as conditions of the probationary period. He did not receive a state prison sentence, a disposition that survivors' advocacy organizations, including SNAP, characterized as inadequate given the documented conduct and the institutional history that had allowed it to continue. The civil litigation against both the Archdiocese of Newark and the Diocese of Orlando proceeded on theories of institutional negligence and failure to disclose known risk. Both dioceses ultimately reached financial settlement agreements with the named complainant in 2010. The settlement amounts were not publicly disclosed, but the resolution of both cases was confirmed by civil court records. The civil proceedings produced a formal legal record of the communication between the two dioceses, or the lack thereof, and of the sworn affidavit provided by the Newark auxiliary bishop. That affidavit, and the post-termination recommendation letters sent to 6 Florida dioceses, became central to the civil claims about institutional accountability. The Florida Attorney General's statewide review of clergy misconduct, released in 2020, examined the Gorak case within a broader pattern of priests being transferred across state lines without full disclosure of complaint histories to receiving dioceses. The AG report found that 81 of the 97 credibly accused priests identified in Florida had been assigned there after being accused in other states. The Gorak case was not a child abuse case. The named complainant was an adult, but it illustrated the same structural dynamics of institutional transfer without transparency that the AG report identified as a systemic concern across all categories of clergy misconduct. Case 7. Father Jose Palimattom, Diocese of Palm Beach. Father Jose Palimattom arrived at Holy Name of Jesus Catholic Church in West Palm Beach in December of 2014. He had come to the United States from India, where he had served as a priest prior to his assignment in Florida. Within weeks of his arrival at the West Palm Beach parish, the church's music minister received a direct complaint from a 14-year-old boy who was a member of the parish community. The boy told the music minister that Palimattom had shown him multiple photographs containing child pornography. The music minister immediately brought the complaint to the parish administrator, Reverend John Gallagher. Gallagher contacted the Palm Beach County Sheriff's Office. What law enforcement learned in the days that followed raised questions not only about Palimattom's conduct in Lakewood, but about the institutional decision that had placed him in a Florida parish in the first instance. The most significant disclosure to emerge in the course of the investigation was twofold. First, Reverend Gallagher told investigators that when Palimattom was assigned to Holy Name of Jesus, Gallagher had been specifically instructed by diocesan officials that Palimattom was to have no contact with minors without another adult present at all times. The existence of that instruction confirmed that the Diocese of Palm Beach had possessed information suggesting a need for restrictions on Palimattom's contact with young people before he arrived at the parish. The instruction was not communicated to parish members, to families with children in the parish, or to the 14-year-old boy's family. Second, during the course of the criminal investigation, Palimattom himself disclosed to investigators that he had admitted to church officials in India to having engaged in misconduct with a minor there. He stated that Indian church officials had been aware of that admission prior to his transfer to the United States. The combination of this prior admission and the diocesan restriction on contact with minors created a documented institutional record of known risk that had preceded any contact with children at Holy Name of Jesus by several years. Palimattom was arrested in January of 2015. He was charged with possessing child pornography and showing pornographic material to a minor, both violations under Florida statute. He entered a guilty plea to the charges. The court sentenced him to 6 months in the Palm Beach County Jail. Following the completion of his sentence, federal immigration authorities initiated removal proceedings. He was deported to India in June of 2015. The Palm Beach County case against Palimattom was resolved within a relatively short period, from December arrest to completion of sentence and deportation within approximately 6 months. Its significance in the broader context of Florida clergy accountability cases was not the scale of the sentence, but the documentation it produced about the institutional circumstances of his assignment. The pre-assignment instruction to Gallagher, that Palimattom was not to have unsupervised access to minors, appeared in the law enforcement record and in reporting by Florida news organizations. It raised a formal legal and institutional question. If a diocese knew enough about a priest's history to restrict his access to children, what obligation did that diocese have to inform the parish community, the parish administrator, and the families whose children were members of that parish? The Diocese of Palm Beach did not issue a detailed public statement addressing the pre-assignment restriction and its basis. Church accountability advocates, including SNAP, publicly called for a full accounting of what diocesan officials had known about Palimattom's history at the time of his assignment and of the basis for the access restrictions that had been communicated to Gallagher. The diocese's prior history, which included the resignations of 2 successive bishops over misconduct, had left the institution under intensified public scrutiny, and the Palimattom case added to that accumulated record. The case was included in the Florida Attorney General's 2020 statewide review within its documentation of credibly accused priests in the Diocese of Palm Beach. The diocese published a list of credibly accused clergy in compliance with the AG review requirements. Palimattom's name appeared on that list. His deportation to India following sentencing meant that Florida's sex offender registration requirements did not apply in the conventional domestic sense, as he was no longer a resident or present in the United States. His criminal conviction remains in the Palm Beach County Court record. From the standpoint of investigative process, the Palimattom case was resolved through a combination of the minor complainant's direct report, the music minister's immediate escalation to the parish administrator, and Gallagher's immediate contact with law enforcement. The institutional response at the parish level, the music minister escalating within hours, the administrator calling law enforcement the same day, was cited by advocates as an example of how mandatory reporting protocols, when followed, function as intended. The institutional failure, by contrast, was in the conditions that preceded the assignment and in the gap between what diocesan officials knew and what parish-level staff and community members were informed. Case 8. Father Richard Murphy and Deborah Lynn True, Vero Beach. Father Richard Murphy died on March 22, 2020, at the age of 80. He had served as pastor of Holy Cross Catholic Church in Vero Beach for years, and his death appeared, on its face, to mark the end of a pastoral career. What it actually marked was the beginning of a financial investigation that would take 4 years to reach a courtroom, an investigation that documented a deliberate, multi-year scheme to divert parishioner donations away from the parish's official accounts and into a hidden bank account that neither the Diocese of Palm Beach nor the parish community knew existed. Murphy died before he could be prosecuted. His co-conspirator, Deborah Lynn True, did not. The scheme began, according to law enforcement records, in 2012. Murphy and True, who served as the parish administrator at Holy Cross, opened a bank account at PNC Bank. The account was opened in the name Holy Cross Catholic Church, which caused it to appear, to anyone who encountered a reference to it, as a legitimate parish financial account. It was not. It was unknown to the Diocese of Palm Beach, unknown to the parish's financial committee, and unknown to the broader Holy Cross community. It did not appear on any quarterly financial report submitted to the diocese. Over the 8 years from 2012 until Murphy's death in 2020, a total of $1,466,331 in parishioner donations was funneled into this concealed account rather than into the parish's official diocesan accounts. The investigation documented how the funds were used once they reached the concealed account. $549,289 was used to pay off True's personal lines of credit. An additional $147,000 was deposited directly into her personal checking account. Murphy also personally benefited from the account, according to the Vero Beach Police Department's investigation, though the specific amounts attributed to him could not be fully determined because he died before investigators gained full access to the account records and before any formal interview process could be conducted. The concealed account was never discovered during Murphy's lifetime. When Murphy died in March of 2020, the Diocese of Palm Beach appointed a new pastor to Holy Cross. The new pastor brought in a new bookkeeper to manage parish finances. During the routine process of reviewing Holy Cross financial records, the new bookkeeper identified a bank account, the PNC account, that had never appeared in any of the quarterly financial reports submitted to the diocese during Murphy's tenure. The discovery was made in late 2020 or early 2021. The Diocese of Palm Beach contacted the Vero Beach Police Department, which launched a formal criminal investigation in December of 2021. The 9-month investigation involved review of financial records, bank documents, and interviews with individuals associated with the parish during Murphy's tenure. In September of 2022, investigators conducted a telephone interview with True. During that interview, True acknowledged that Murphy had instructed her not to disclose the PNC account to diocesan officials. She further acknowledged that Murphy had authorized her to use donated funds for her personal expenses, characterizing his conduct toward her as a form of personal generosity in recognition of her long hours and service to the parish. True told investigators, "Father Murphy was very generous to a fault. He would do things like that for me because I put in so many days and hours in working." That statement was documented in the police report and subsequently became part of the sentencing record. True turned herself in at the Indian River County Jail on September 19, 2022, and was released on $25,000 bond. She was charged with first-degree grand theft. The case worked its way through the Indian River County court system over the next 2 years. On May 1, 2024, True entered a plea of no contest to the first-degree grand theft charge. Sentencing took place on July 18, 2024. The court sentenced True to 10 years in state prison and ordered her to pay restitution in the amount of $697,138 to Holy Cross Catholic Church. She was also barred from any future contact with the parish in any capacity. No criminal prosecution of Murphy was pursued, as he had died more than 2 years before charges were filed. The civil and institutional implications of his role in the scheme remained a matter of record, however. The Diocese of Palm Beach acknowledged the theft and the internal discovery process that had uncovered it. Holy Cross parishioners were informed of the investigation and its findings through parish communications. The case was not part of the Florida Attorney General's 2020 clergy investigation, as that investigation closed before the PNC account was discovered. It therefore represents a documented case of financial misconduct in a Florida Catholic parish that arose and was prosecuted entirely after the formal conclusion of the AG's review. The Murphy and True case raised several questions about parish financial oversight that the Diocese of Palm Beach and church accountability organizations addressed in the investigation's aftermath. The mechanism that ultimately revealed the scheme was not an audit, not a diocesan review, and not a complaint from a parishioner. It was a routine bookkeeping review conducted by a new employee after a pastoral transition. The 8-year concealment period, from 2012 to Murphy's death in 2020, reflected the absence of independent financial controls at Holy Cross during that period. Case 9. Pastor Sylvester Ofori, Orlando. The criminal case against Sylvester Ofori was documented by multiple witnesses, captured on surveillance video, and resolved by a jury in Orange County, Florida, in July of 2024. Ofori was not a Catholic priest. He was the pastor and self-described prophet of Floodgates of Heaven International Ministries, a non-denominational congregation based in Orlando with more than 60,000 followers on social media at the time of the crime. His victim was his estranged wife, Barbara Tommy, 27 years old. She was killed in the parking area of her workplace on the morning of September 8, 2020. The case resulted in a first-degree murder conviction and a life sentence. Ofori and Tommy had been married approximately 5 years. By September of 2020, the marriage had deteriorated to the point that Tommy had initiated divorce proceedings and the couple were living separately. Family members who testified at trial documented a history of domestic conflict within the marriage. 2 days before September 8, 2020, Ofori confronted Tommy and family members at a location connected to her. During that confrontation, which was recorded on a mobile device by a family member, Ofori stated directly that he intended to cause her harm. He addressed her brother-in-law and stated, in words captured on the recording, that if he did not carry out what he had threatened, he should be considered someone whose word meant nothing. Tommy's brother urged her to contact law enforcement. She declined, expressing concern that doing so would escalate the situation further. That recording was admitted into evidence at trial. On the morning of September 8, Tommy arrived at her job at a Navy Federal Credit Union branch on Gardens Park Boulevard in Orlando. She parked her vehicle and entered the building to begin her shift. At some point during the morning, she stepped outside. The specific reason was not established in the trial record as a central fact, and Ofori was present in the parking area. He was armed with a firearm. Tommy turned and moved toward the credit union entrance. Surveillance cameras on the exterior of the building recorded what followed. Ofori approached her, and when she reached the credit union door and was unable to immediately gain entry, he struck her with the firearm and then fired multiple times. She was struck by multiple rounds and fell to the ground. Additional shots were fired after she had fallen. She was transported to Orlando Regional Medical Center, where she was pronounced dead. Ofori fled the scene in a rented Dodge Journey. A law enforcement investigation involving the Orange County Sheriff's Office and Orlando Police Department was initiated immediately. Investigators identified the rental vehicle, traced Ofori's movements through cell phone data and surveillance footage from the surrounding area, and located him at his apartment the following day, September 9, 2020. He was arrested on charges of first-degree premeditated murder with a firearm. The criminal case proceeded through the Orange County Circuit Court over the following years. In April of 2023, Ofori rejected a plea agreement that would have resolved the case with a sentence of 50 years. His decision to reject the offer and proceed to trial was documented in the court record. The trial took place in July of 2024. Over 3 days of testimony, the prosecution presented nearly a dozen witnesses, including employees and customers of the Navy Federal Credit Union who had been present at or near the scene, family members of Tommy who testified about prior incidents and a pre-murder threat, and law enforcement investigators who had processed the scene and led the arrest. The surveillance video from the credit union, which captured the events of September 8th in substantial detail, was admitted into evidence and played for the jury. The recorded statement from 2 days before the murder, in which Ofori had stated his intent, was also admitted. After deliberating, the jury returned a verdict of guilty on the charge of first-degree murder with a firearm. Circuit Judge Michael S. Cranick presided over the sentencing hearing. He sentenced Ofori to life in prison, with a mandatory minimum of 25 years before any eligibility for parole consideration could be raised under Florida law. The case was prosecuted by the Orange Osceola State Attorney's Office. The Ofori case entered the public record as a case involving a faith leader, and it was covered by Florida news organizations and church affairs publications in that context. Floodgates of Heaven International Ministries, the congregation Ofori led, had a documented social media presence and a congregational community in the Orlando area. The case illustrated, in a context distinct from the Catholic clergy abuse cases documented elsewhere in Florida's investigative record, that the category of faith leader misconduct is not limited to a single denomination or institutional structure. The legal proceedings in Orange County Circuit Court addressed the criminal conduct directly, and the conviction on first-degree murder produced the most severe sentence available under Florida law. Case 10. Bishop Joseph Keith Symons, Diocese of Palm Beach. In the spring of 1998, the Diocese of Palm Beach entered a period that would become one of the most documented institutional crises in the history of the American Catholic Church in Florida. The catalyst was a disclosure made by a 53-year-old man to the Archdiocese of Miami, a disclosure that a priest he had known as a child, who had since risen to become the sitting bishop of the Diocese of Palm Beach, had engaged in misconduct against him when he was a minor. The priest was Joseph Keith Symons. When the Archdiocese of Miami confronted him, he did not deny the account. He acknowledged it. He then acknowledged 4 additional victims. On June 2, 1998, Pope John Paul II accepted his resignation. Symons became the first sitting Catholic bishop in the United States to lose his position as a direct consequence of his own admission of sexual misconduct with minors. Symons had been appointed Bishop of Palm Beach in 1990 and had served in that role for 8 years at the time of his resignation. Prior to the Palm Beach appointment, he had served in the Archdiocese of Miami and in the Diocese of Pensacola-Tallahassee. The conduct he admitted to had occurred years earlier, when he was a parish priest in the Miami Archdiocese. The victim who came forward in 1998 told archdiocesan officials that Symons had engaged in misconduct against him over approximately 3 years beginning when the victim was 13 years old, starting around 1958. The conduct had been concealed for roughly 40 years before the disclosure was made. When the Archdiocese of Miami received the disclosure and confronted Symons, he confirmed the account. The Vatican dispatched Bishop Robert Lynch of the Diocese of St. Petersburg to conduct a formal canonical interview. During that interview, Symons disclosed the existence of 4 additional individuals against whom he acknowledged engaging in similar conduct earlier in his ministry. He described the nature of those encounters in terms that investigators and canonical reviewers documented in their formal reports. Accounts included social events, meals at restaurants, overnight stays at motels, and situations in which children shared sleeping arrangements with him. The admitted conduct occurred across several years of his early priestly ministry in South Florida. No charges were filed in any of these cases because the conduct had occurred decades earlier and the applicable statutes of limitations had expired long before the disclosure was made in 1998. The resignation was accepted by the Vatican on June 2, 1998, following a brief period in which the archdiocese and diocesan leadership managed the canonical and public disclosure process. The announcement was handled jointly by church officials, and Symons issued a personal statement acknowledging his conduct and expressing public acknowledgement of the harm caused. The Diocese of Palm Beach made a formal announcement, and the matter was covered extensively by Florida and national press. A formal investigative review was subsequently conducted by the Pinellas Pasco State Attorney's Office, which examined whether any of Symons' admitted conduct fell within an applicable legal window that would have allowed prosecution. That review determined that all of the admitted conduct fell outside of any available statute of limitations, and no criminal charges were filed. The state attorney's review records, however, revealed an additional institutional dimension to the case. Documentation showed that a victim had brought an account of Symons' conduct to Bishop John M. Smith of the Diocese of Pensacola-Tallahassee in December of 1995, more than 2 years before the 1998 public disclosure. At a meeting following that report, Symons admitted his conduct to Smith. He denied additional victims at that time. No public disclosure was made, no law enforcement contact was initiated, and Symons continued to serve as Bishop of Palm Beach for 2 years and 5 months after that private admission. The institutional aftermath of Symons' resignation extended well beyond the immediate crisis. His successor, Bishop Anthony O'Connell, was appointed to lead the Diocese of Palm Beach following Symons' departure. In 2002, approximately 4 years after Symons resigned, O'Connell appeared before Palm Beach County Press and disclosed that he too had engaged in misconduct with a seminarian in Missouri years earlier. He submitted his resignation to the Vatican the same day and was replaced. The Diocese of Palm Beach had now lost 2 successive bishops, the first through his own admission of misconduct with minors, the second through a separate admission of his own. The Vatican eventually appointed Cardinal Sean O'Malley, then serving as Bishop of the Diocese of Palm Beach, who later became Archbishop of Boston and eventually a cardinal, to stabilize the institution. The Symons case occupies a distinctive place in the Florida and national record of clergy accountability for a specific institutional reason. He was a bishop, not a parish priest. The formal structural relationship between a bishop and the Vatican, in which bishops are directly appointed and supervised by the Holy See, meant that his resignation required and received direct Vatican approval. The documentation of the 1995 private admission to Bishop Smith, the 2-year continuation of Symons' ministry after that private admission, and the 4-decade period between the conduct and the public disclosure collectively illustrate the full span of institutional conditions that the Florida Attorney General's 2020 statewide investigation described as structural problems rather than individual failures. Symons remains the first and, as of the time of this documentary's research, the only sitting Catholic bishop in the United States to have resigned from that position as a direct result of his personal admission of sexual misconduct with minors. If you made it this far, hit the like button, drop a comment below with which case you want us to cover next, and subscribe to Crime Doc so you never miss an upload. See you in the next case.